Good afternoon. I have a brief announcement to make before I give the floor to our moderator. We are increasingly concerned with sustainability in this Congress. For this edition, we have made several efforts to make this a sustainable event and to offset our carbon footprint. This year, we are also holding this event online, allowing for a greater number of participants. In the case of on-site participants, we have preferred this hotel to prevent commuting. In the exhibition hall, all of the materials are to be recycled and reused. We have decreased by 90% all printed material, and the event program is online only. We have also decreased the number of disposable materials, and also we are using less plastic bottles. Moreover, at the end of this event, we will be collecting your ID cards back. So if you can kindly return them, we will use them next year again. All of the tissues for the panels have been donated by the company that has put this event together, and this will be donated to an NGO that is going to make cloth dolls later on. We will also buy carbon credits to offset the remainder of the footprint, and we are honored to bring this meeting in line with sustainable initiatives. Thank you very much for your attention. Our moderator has the floor, Dr. Luis Edgar Monterrey Pimenta. Good afternoon to all of you. I'm very glad to see that we have a full house, and I feel very honored on behalf of Miguel and Etienne. We have Dr. Claudio Furtado, president of ANPI, the top management of ANPI, Claudio Leonardo's, and the president of ABPI. So we feel very honored by the presence of all these people. Our topic here today is very much up to date and attractive. This is the result of an initiative we had, which I believe that was a pioneer in Brazil, to create this Interministerial group for intellectual property legislation. This is being led by Miguel, and I'm going to introduce him later. This counts on the participation of civil society, and a few agencies of civil society have been invited, among them ABPI. ABPI is very honored to be part of this privileged group. And we have been holding regular meetings. I think that not everybody is aware of how many meetings there have been that have been held. There are also several study committees of IBPI. They also prepare materials to be submitted to this group and ABPI. So I'm going to introduce Miguel and Etienne, who is the CEO of INTA, to take part on this panel with us. Etienne will speak first. He is the CEO of INTA. He works with the board of directors to formulate and implement policies and programs for the International Trademark Association, and he is responsible for the administrative of the association, supervision, the staff, development, administration of the yearly budget. Before that, Etienne was the head of communications of the IP Office of the European Union. He has a graduate studies from the Free University of Brussels and also from a renowned business school. Miguel, I am going to summarize your very extensive committee. He is a public civil servant. His foreign trade analyst has experienced intellectual property, and he is now working for the Subsecretary of Innovation and Digital Transformation of the Ministry of Economics, and he is the advisor for 4.0 economy and IP. He is coordinating the implementation of the national strategy of IP, and he's the secretary of the Interministerial group of IP. Miguel, if you allow me, I don't think you're just a secretary. You are coordinating and making everybody to comply with deadlines and express their opinions. This is more than just to be a secretary, as I see it. Miguel started working as a foreign trade international at the Alexandre de Guzmão Foundation. He has a master's in foreign relations by Brasilia University. And with that, I will give the floor to Etienne. Como vai, Etienne? Eu não sei onde é que você está exatamente, espero que esteja tudo bem com você, mas você está com a palavra. Boa tarde, Edgar. Boa tarde a todos. First of all, I'd like to thank ABPI for extending to me this invitation to speak to you today. I would also like to congratulate ABPI for this Congress, which is already a success. I would love to be with you in person, but unfortunately, I have other commitments who force me to be with you only remotely. Even so, it is an honor to be together with a great co-panelist and a great moderator. I would also like to greet Dr. Claudio Furtado, Dr. Gabriel Leonardos, and Dr. Luis Enrique do Amaral, all of them great friends. E depois desse esforço em português, vão me desculpar se eu passar agora para o inglês. Eu adoro o Brasil, adoro fazer parte das reuniões da ABPI, do Congresso. Infelizmente não pude vir, mas gostaria de agradecer por sempre serem tão acolhedores e serem uma associação tão maravilhosa. E eu gostaria agora de compartilhar a minha tela com todos os senhores, na esperança de que funcione. Eu gostaria de saber, então, se conseguem ver a tela. Vamos voltar aqui muito rapidamente. Estão vendo a tela? Eu vou achar que sim. Então, a INTA talvez seja a maior organização de marcas do mundo. Nós temos entre 6.500 e 7.000 empresas, escritórios de advocacia, empresas do mundo inteiro. Estamos presentes em 185 países. Eu sempre digo que a nossa missão é muito simples e complexa ao mesmo tempo, que é promover a promoção e a proteção dos detentores de marca. Nós estamos aqui no nosso plano estratégico de 2022 a 2025 e essas são as três principais direções e estratégias de promoção e proteção das marcas, construir uma sociedade melhor através das marcas e, por último, sustentar o desenvolvimento da proteção de IPI. Quando falamos de IPI, marcas, desenhos ou qualquer tipo de direito de IPI, a primeira pergunta a nos fazermos é se há um crescimento sustentável em termos de marcas registradas. Aqui nós temos as estatísticas da OMP, infelizmente, como podem ver, elas param em 2020, mas como podem observar, com os anos tem havido um crescimento grande nos depósitos por marcas pelo mundo afora, o que se verifica em todas as regiões. É claro que essas estatísticas se interromperam em 2020 e será muito interessante analisar a situação atual. Esta parece muito com a crise pela qual passamos há alguns anos, ou seja, de que houve uma queda nos depósitos que ocorreu e, gradativamente, isso vai se recuperando. O que é interessante observar é que, se nós formos ver as tendências atuais no México, no Brasil, no Chile e na Argentina, observamos que, de acordo com os números do primeiro semestre de 2022, o México poderia ter uma redução de 9% nos depósitos, o Brasil talvez 5%, Chile por volta de 8% e a Argentina 3% mais ou menos. E isso está de acordo com as principais economias. Vemos uma tendência semelhante tanto nos Estados Unidos quanto na União Europeia. A União Europeia atualmente está em menos 11%, mas como tudo mais nessa crise, sabemos que é uma coisa temporária. Portanto, passando a API, especialmente marcas e marcas registradas, quais são as principais prioridades? Na verdade, é reconhecer o valor das marcas, porque é o que é importante para as empresas. Então, temos as políticas no mundo inteiro, precisamos fortalecer a confiança do consumidor e fidelidade à marca. E uma coisa que é importante na América Latina, precisamos combater um sentimento contra tudo isso e precisamos demonstrar que PI é valiosa e tangível. E a segunda prioridade é a harmonização dos direitos de marca e conexos, e aqui falamos sobre tratados internacionais, como o de Madrid, o sistema da AIA, e falamos de outras coisas também. Falamos do reconhecimento pelo mundo afora de marcas não tradicionais, até marcas de serviços agora que podem ser reconhecidas, e falaremos também da concorrência. A prioridade número 3 é a falsificação, e vou voltar a isso daqui a pouco, a contrafacção, e precisamos cada vez mais analisar um fenômeno que se iniciou com as embalagens de marca e de cigarro, de tabaco, que é o que nós chamamos de restrições de marca, e precisamos também ver a governança da internet e o futuro, especialmente em termos de metaverso. Falsificação, eu não vou detalhar, mas nós temos aqui um slide que eu acho que é bem interessante. De acordo com os dados da OCDE de 2021, o valor dos bens falsificados vendidos anualmente fica entre 1,7 e 4,5 trilhões de dólares. E sabemos que afeta especialmente setores da indústria como sapatos, vestuário, couro, maquinário elétrico, produtos farmacêuticos e, na verdade, todos os setores da atividade. Um outro fenômeno que observamos é que os falsificadores são profissionais muito bons, na verdade, se aproveitam das situações tais como a da Covid-19. E nós estamos trabalhando nesse sentido e fizemos um relatório contra a falsificação em 2019, a nova versão será apresentada em algum momento de 2023, e aqui sobre os membros da América Latina. O subcomitê da América Latina é, de longe, o maior, o que atesta a sua importância. Eu mencionava antes sobre as restrições de marca. Aqui eu estou colocando na tela um estudo que nós realizamos em 2021, que analisa as restrições de marca e suas percepções pelos Gen Zeros e os milênios ou da geração zero e milênios. E, na verdade, é ver como as restrições de marca estão afetando o comportamento do consumidor. Fica claro que as restrições de marca impedem que os consumidores tomem decisões corretas e afeta-os em termos do seu comportamento de compra, o que é uma grande preocupação para nós. E fica claro que retirar a marca a embalagem do produto não é a única solução. Na maioria dos casos, não é o que se deve fazer. Eu mencionei anteriormente a expansão do sistema de domínios da internet, e aqui falamos sobre do mecanismo RUIS, falamos de uma expansão ainda maior dos GTLDs e da melhoria dos processos ICANN, e falamos também sobre as novas políticas para os domínios descentralizados, ou seja, os blockchain. Para dar uma ideia, em 1995 só havia 9 TLDs e hoje mais de 1.500, provavelmente até mais do que 2.000, e para dar uma ideia dos números, se nós formos ver no metaverso, nós entramos num mundo novo a desbravar. E o que está acontecendo com o metaverso? E eu falo dos metaversos plural. Nós sabemos que, por natureza, eles são completamente descentralizados, não gostam de nenhum tipo de regulamentação. Existe um número incontável deles e não há nenhuma estrutura de IPI a esse respeito. Então, o que acontece com o que aconteceu com os domínios há 30 anos atrás está sendo reproduzido agora de forma exponencial dentro dos metaversos. Então, uma coisa que a INTA está estudando muito, em outubro vamos lançar um relatório sobre o estado da técnica, qual é a interação entre a regulamentação atual e as marcas e aquilo que deveriam ser as medidas para proteger as marcas nos metaversos. E a INTA continua a se projetar para o futuro. Temos aqui relatórios que estão à disposição no nosso website. Para aqueles que não tiveram oportunidade de ler, nós trabalhamos com escritórios de advocacia, departamentos jurídicos, para ver qual será o futuro de um escritório de PI, de uma regulamentação de PI, etc. E nós planejamos continuar a trabalhar dessa forma, vendo qual é o futuro do judiciário do PI e também observar quais seriam os direitos de PI do futuro. Igualmente, pode parecer como ficção científica para os senhores, mas na verdade não é. Nós estamos vendo missões comerciais indo para a Lua, estamos pensando até em Marte. Então, qual seria a proteção de PI no espaço sideral, que é o que vem fazendo a INTA, e vamos também lançar um relatório e um white paper em novembro desse ano. A ideia é dar ideias sobre como a produção de IPI poderia se estabelecer no espaço sideral para oferecer isso para a OMP, para que talvez eles possam imaginar algum tipo de tratado internacional ou harmonização. Muito rapidamente, eu gostaria de concluir falando de alguns dos desafios que observamos na América Latina, com os olhos da INTA. Número 1, temos restrições de marca. Nós temos alguns países que realmente são problemáticos para os detentores de marca, como o Chile, Argentina e até certo ponto o México. E observamos agora uma certa movimentação na República Dominicana e no Panamá, que são muito preocupantes. E no caso do Brasil, eu diria que não foi tanto o caso até o momento. Entretanto, sempre precisamos ficar de olho. E tem muito a ver com política, infelizmente. Então, talvez possamos discutir sobre isso posteriormente. Em segundo lugar, os direitos de IPI têm um risco de perder a sua proteção em âmbito constitucional. Não sei se muitos dos senhores conhecem a esse respeito na sala, mas houve uma discussão recente para se fazer uma emenda à Constituição chilena e, como parte disso, os direitos de PI perderiam proteção constitucional. E isso ainda deve ser confirmado e votado pelo público em geral. No caso de assim o ser, poderia também se expandir para outros países da região. Outras questões a se considerar é que, em alguns casos, a legislação desatualizada, há países que estão muito avançados, outros que decididamente não, e nós vemos que não há ações ex officio em termos de fronteiras, não há uma ação comum contra a falsificação, e mesmo em alguns países as marcas de serviços não são reconhecidas ou não há proteção para qualquer marca que não seja tradicional. Antes eu mencionava da importância da falsificação. Uma das principais questões é a inutilização de artigos falsificados, e com a pandemia o tráfico ilícito aumentou, sem dúvida, que é uma coisa que não está sendo ainda resolvida adequadamente pelas nossas autoridades. Com isso, então, eu sei que talvez eu tenha estourado um pouquinho meu tempo, então gostaria de agradecer a todos pela atenção e será um prazer ver a apresentação do meu colega Miguel aqui no painel e depois teremos o debate. Muito obrigado. Muito obrigado, Etienne, pela apresentação tão interessante. I think that this presentation by Etienne correlates very much to what Miguel is going to speak about now, which is harmonization of laws and the greater concerns that are found in other countries. To see this with the eyes of the Brazilian reality, we have evolved here in Brazil with the Protocol of Madrid. Dr. Felipe, who's the brand director at INPI, is here with us. We're going to profit from his presence, and there are things that really have to pay attention to. There's the Madrid Protocol, yes, but there is still some adjustments that are lacking. There are other issues that were implemented by the Madrid Protocol, but that still call for an adjustment. Once again, I'd like to congratulate him because the time for a brand request in Brazil is in line with what we have internationally. So before giving the floor to Miguel, I'd like to say a word of clarification. May we please leave 10 minutes at the end so that we can have an open discussion. Miguel, you have the floor.
Thank you, Luis Edgar. I'll stand at the lectern because I have some slides I'd like to share with you. So wonderful to have a full house to share with you the work we've been doing at the Brazilian Trademark Office in reviewing the industrial property law. Etienne gave me the perfect segue when he talked about outdated legal framework. So that's what we've been doing at the Ministry of Economy, updating those. Could you please pull my slides up? I'll just wait until my presentation is up on the screen. Etienne, I was really happy to hear you talk about IP Task Force as science fiction fund. I'd like to hear more about that. Thank you. As I said, the work we're doing at GIPI, which is coordinating the national strategy on intellectual property, will be reviewing the legal framework on intellectual property in Brazil. So we have some initiatives set out in the track number 4 of the strategy, which are being addressed by the work that is being carried out by the technical group created at GIPI for that purpose. We want to create space for the interaction among different IP actors with the participation of public agents and civil society to identify the needs to update legal and infra-legal frameworks with users and to map bottlenecks and critical points to review and strengthen the Brazilian legislation for geographical indications, whether in the intellectual property law or our own legislation, and to enhance, update, and create a draft bill. So those are our objectives when working on intellectual property legislation in Brazil. I will be talking about copyright law, even though that is not the objective of the GIPI working group, because this is technical work that is being done by the Subsecretary of Copyright under the Ministry of Tourism. There has been public consultation, and they're looking into the results of the public consultation so that they can come up with a proposal to update that specific act. We know that the legal framework on IP in Brazil, and you know this more than I, is quite old. It's from the 90s. We did include the triple agreement, and the idea was to standardize the national legal framework. That's why a technical working group was created at the GIPI to standardize the legal framework on intellectual property to identify any needs to update specific points. This working group will last a year. The technical groups under the federal government, collegiate, have to have a limited term. Ours is a year, so it will conclude on the 7th of March 2023. At the end of that term, we hope to have consolidated technical proposals to update our normative framework on intellectual property. And the work has been focusing on the IP law, because the copyright law is the objective of another group. So the technical group includes 10 members, according to Resolution GIPI 2003 from the 25th of February 2022. So the Ministry of Economy, Agriculture, the INPI, ABPI, ABPI, Farmer Brazil, Fortec, AMPEA, and CropLife Brazil. Under the technical group, we have those members, but that's not exhaustive. Other agencies and experts can join us and make their contribution. And we have planned 4 deliverables to identify preliminary information. So we've done that. We've identified points for review on industrial property legislation. We've also identified bills that are going through Congress to do with intellectual property issues, and we have also identified specific lawsuits that are the object of frequent lawsuits in Brazil. The second deliverable was organizing all the information we have compiled and mapping provisions that need to be reviewed and updated. So the GIPI technical group decided to prioritize some of the topics that were identified and organized in what we've called technical debates. There are 13 of those, which are not limited to the 10 members, and they will discuss regulatory issues that have been identified and come up with proposals based on technical grounds that will be presented to the Interministerial group. So we are currently in the technical discussion phase to come up with proposals for the normative review. And the final deliverable will be a deliverable report with all the different technical proposals. So the technical working group came up with the first 2 points I mentioned earlier, and we have some data to share with you. Many proposals to review the intellectual property law were put forward on trademarks, patents, industrial designs. So trademarks and patents have been broken down into technical groups, and we also have 3 technical groups for contracts. The other topics, industrial designs, have a specific group, geographical indications also. There's another group that will be focusing on the IP law itself. In terms of lawsuits, many were identified recently. They came from the paragraph under Article 40th, which was revoked. Pending patents is another point. Mailbox patents, pipeline patents, skills patents, and we also have the application division and amendments. About the bills that are ongoing in Congress, there are many bills to do with R&D and innovation, and under industrial property, the bills about patents had the most proposals. And now I'd like to give you a summarized overview of the technical groups that were created to discuss proposals to review the IP law. In the patent groups, these were the different topics. Many different points were raised, so patentability, application division, terms, amendments, and based on these results, we decided to organize these technical groups. The first one focusing on patentability, coordinated by the Brazilian Trademark Office, specifically by Claudia, who's sitting here in front of me. A second patent group focusing on addition certificates, focusing on applications and application division, coordinated by Pharma Brazil and CropLife Brazil. A technical group called Patent 3, focusing on patent terms and compensation for concession delays. That's being coordinated by the Ministry of Economy under my leadership. And Patents 4, focusing on fostering patents. In other words, how to foster regulatory measures that can promote patent applications and patents in Brazil. This is being coordinated by ABPI and Fortec. Under contracts, as I said, there are 3 different technical groups. The first one focusing on discussing registration and contract amendments. This is being coordinated by the Brazilian Trademark Office. A second group will be discussing limits on royalty deductibility, which includes lots of legislation on this topic, including income tax. And the third technical group is on essential patents and friend terms on technology contracts, which is being coordinated by ABPI. And the second group is being coordinated by Natalia from the Ministry of Economy. Under trademarks, there are 3 groups. The first one will be focusing on the statute of limitations, coordinated by ABPI. There's been a lot of debate about this topic. The second group will be focusing on the administrative process in trademark registration at the INPI. We want to update the legislation according to new registration, because the legislation comes from a time when registration happened on paperwork. So the whole process has been updated, and we need to update the administrative process. And the third group will be focusing on trademark rights, registrability, more specifically secondary meaning, and advertising and brands. This was put forward by INPI. Under industrial designs, there's only one technical group focusing on 3 different topics. As you can see, the priorities do reflect the charts that we see on the left-hand side. These are the most frequent topics that were identified by the technical work that was carried out. So the 3 topics are application division, the registration of applications, registrability, and registration terms. This group is being coordinated by INPI and ANPE. Under geographical indications, and just quickly on this, this is a very broad scope because in addition to the technical debate on the legal framework for geographical indications discussing the definition of geographical designation, the use of geography as an ingredient in different products, there is another technical group under the GIPI which will be focusing on control and traceability of geographical indications. The normative framework is very streamlined, and there are many topics that need better regulation to provide more security to the rights holder. This is being coordinated by the INPI and the Ministry of Agriculture. And the geographical indication technical group is being coordinated by the Ministry of Agriculture as well. And other provisions under the intellectual property law, we are discussing statements, appeals, terms, payment, withdrawals. This was raised by some IP users, especially CTs, public CTs, which sometimes have difficulty keeping to the intellectual property law terms. So in some cases, they need additional statements and longer terms. So that's the idea, and this group is being coordinated by the ABPI. And at the end of the work carried out by the different groups, we'll have a script with different points that were proposed to the coordinators of each technical group. So they should identify one regulatory issue, and this is based on the regulatory impact assessment, which has become compulsory to the federal government. Before making any changes to the regulation, it can't be done without a regulatory impact assessment, and this is also a starting point to roll this out. So we will be identifying one regulatory issue that needs to be solved, the main economic agents that are affected by that issue, the different public agencies that are affected by that issue, a technical presentation of the proposal, the technical grounds for that proposal, international benchmarking, including best practices for this issue, and then we'll decide whether it's possible to come to a consensus, whether there is any dissension, explain what they are, and at the end of it all, to come up with a proposal to update the solution for the issue that was raised. So that's what we've been doing in our technical groups under the GIPI, which is part of this broader technical group that I mentioned, which is assessing the normative framework on intellectual property. I see many faces here that have been taking active part in these debates, and I want to thank you because I know it's been hard work. But I do believe it is a constructive process, and I hope it's been a productive experience to all of us. Thank you. Thank you, Miguel. A very enlightening presentation. I think this is a unique opportunity to share the problems that we experience in our everyday life at the Brazilian trade office market, and to share that with the government and hopefully plan for changes. You mentioned a couple of points that really, one of them is about regulation. We've talked to Felipe, the trademark director at the INPI, which is the secondary meaning of trademarks. There has been progress in that regard, and the INPI has been granting trademarks considering secondary meaning. There are plenty of examples of that. So what we really need is to regulate that issue. And another point brought up by the Brazilian trade office market is the lack of registration. Some trademarks are registered or they are denied registration because they are considered advertising. Sometimes there's a single word, and I like to use the example of Coca-Cola and the word enjoy. Coca-Cola registered enjoy as a trademark. The Brazilian trademark office has no way of assessing whether that is a trademark or an advertising. So when it's time to prove that it is being used as a trademark or advertising is quite hard. But the lack of registration, which has been taking place in practice, when this goes to court due to misuse, as it's being used as a slogan by a third party, the lack of registration means you need to come up with much more complex evidence than you would if the registration had been granted by the agency. So before I turn it over, actually before I open the floor for questions, and we have some questions being asked online, I have a comment for you, Miguel. Out of the many members of civil society taking part in this group, there are often conflicting interests. In order to come to a final report, how do you deal with conflicting opinions and diverging opinions? Yeah, well, that's just it. Many people have asked us about that, and I think that's part of the process, and in some cases, it will not be possible to come to a consensus and to come up with a single solution because there are conflicting interests that are being represented in these conversations. So we are encouraging people to reach a consensus, but whenever that is not possible, we need to have technical grounds for the different opinions, and we want people to come up with different proposals which are backed, technically backed, so that in the future we can have technical subsidy to provide the government when the government needs to make a decision. Even if that doesn't happen now, if it happens in the near future, that will be on the record so that the government can use that as input when making decisions on the normative framework on intellectual property. So even when we don't come to a consensus, and that will be hard in the trademark and patents group, the point is to strengthen the discussions on the topic as well. Thank you, Miguel. Etienne, aproveitando o fato de que temos aqui conosco o presidente Furtado e também o nosso diretor de marcas, o Felipe, o que é que você diria que seria um ponto de preocupação de acordo com a perspectiva internacional com relação às marcas aqui no Brasil? Desculpem, eu estava mutado. Excelente pergunta. Eu e o presidente Furtado somos grandes amigos, então eu não sou totalmente imparcial na minha resposta, mas o que eu diria a ele e a sua equipe é que nós esperamos que eles continuem a fazer o trabalho excelente que têm feito. Nós sabemos que muitas vezes os órgãos sofrem com falta de recursos, e essa é uma grande preocupação mundialmente, porque a economia brasileira é uma economia líder na região, precisa de um sistema de IPI forte e precisa de um escritório de IPI robusto, onde a tomada de decisão seja consistente tanto para os detentores de marca quanto para os profissionais, porque muitos dos senhores são profissionais de IPI representando detentores de marca, e muitas vezes é difícil explicar por que um caso está demorando tanto, por que há uma falta de uniformidade na tomada de decisões. Eu sei que o INPE Brasil está trabalhando nisso. Nós só esperamos que as eleições não afetem o trabalho da ABPI e do ecossistema de IPI em geral. Vou parar por aqui. Obrigada, Tien. So, as a segue to what Etienne just said, let's not forget the proposal made by the Brazilian Trademark Office, which was commented on by our chairman, Mr. Leonardos, and Claudio Furtado. The Brazilian Trademark Office has proposed to increase the budget to keep more money than it receives, to be able to hire, to be able to invest in technology, in AI, whatever it might be, in order to improve the system as a whole. That said, I will now open the floor for questions. If we have any from the audience, please raise your hand. And I'm also watching out for questions coming from our virtual participants. President Leonardos. Thank you, Luiz Edgar. Oi, Etienne, prazer vê-lo, mesmo que à distância. Thank you, Miguel, for joining us. I don't want to put you on the spot. Please feel free to answer to my question as diplomatically as you like. This is an election year, and as usual, every 4 years, our concern is with the continuity of the positive initiatives, good policies, and as Luiz Edgar said, the work being carried out by GIPI, which involves civil society, it's very plural. We know that it includes agencies that have opposing opinions on many different topics, and they are working together, and you are conducting that like a maestro, keeping everybody in tune. How do you see stability of bureaucracy? You're part of that effort. If there is a change in politics, and I'm not even saying if the current president doesn't win the elections, we know that even if the current president is re-elected, that may be a reorganization, and that may affect how things are organized publicly. Can you help us with that? I know, it's a tricky question, right? Yeah, it really is difficult. We know that nobody has a crystal ball, but intellectual property is under our Undersecretariat for Innovation. We were part of the Ministry for Foreign Trade and Industry, and now we're part of the Ministry of Economy. But intellectual property is under the same leaders. Myself, Natalia, and Jacqueline, we've been working on it for a long time, and we are prioritizing the intellectual property agenda. And creating the GIPI was a victory. It was reinstated by decree. It had been suspended for a while. It used to exist under the CAMEX, but they weren't doing anything about it. And we moved it away from the Foreign Trade Secretariat because we wanted to work on domestic issues of intellectual property, because CAMEX had to do with foreign trade. It was created after we were working on the 3 pillars. So that was the objective of moving the GIPI away from that. And our number one priority then was creating a national strategy for intellectual property. And that's how things happened. But we are absolutely sure that regardless of the results of the election, we will continue doing the work we're doing. We will continue to prioritize intellectual property under the Secretariat for Innovation, under whatever ministry it might be. Thank you, Miguel. Do we have any further questions from the audience? Hi, Miguel. I have a question for you. This is Suzuki. We know each other from the innovation ecosystem. Miguel, first of all, congratulations on behalf of many of our colleagues for the work you've been doing. As you said, in addition to the partnerships and the associations we see under the GIPI, you have opened things up to civil society as a whole. Could you talk a little bit about how people who are not part of those organizations can make contribution to the work being carried out by the GIPI? Fantastic. Thank you for the question. Well, the technical groups have representatives of each of the entities that would like to participate. So there was a public summons, an informal public summons on our website. It was at the end of my presentation so that anyone who might be interested could take part. So that's now been concluded, but we would like to organize a workshop to involve other agents from society so that we can come to a stage in the work where we can put forward proposals to discuss proposals with other agents so that it's not just limited to our experts. Somebody else had raised their hand? Thank you, Luis. Hi, Miguel. This is Carolina from Interpharma. Thanks for all the explanation. Anyone taking part in the GIPI work knows exactly how things are being structured. We didn't have time to talk about this, but there is a debate, and we see the government doing certain things to standardize Brazil and the OECD. And we know that there are international treaties being discussed. The Ministry of Foreign Trade has made progress in the context of Mercosur, the EU, and as well as other countries. And we know that intellectual property is key to those negotiations. How much of that actually gets to you? How do you see that looking forward? Because I know that you're looking into the normative regulations, but what about these international debates? Do they reach you and your undersecretariat? Well, about Mercosur and the EU, I was very active because when we were in the Secretary for Innovation, we were working actively on international negotiations. Now that the ministries have been merged, this is now under the Secretary for Foreign Trade. So we're not acting on the negotiations, but we are consulted and we do provide our technical opinion. So if it's not too far from our normative framework, we do provide expert opinion. Other agreements, such as the Mercosur Singapore or Mercosur Canada, which is under negotiation right now, for instance, we did provide expert opinion. About the OECD, we are consulted. We don't take active participation in it, but there haven't been many intellectual property issues, and the OECD doesn't have specific recommendations on intellectual property. In fact, if you know of any of them, please let me know, because we haven't been able to identify any. What we have identified at the OECD have been issues to do with competition in intellectual property, much more so than protecting intellectual property rights.
There's one more question here, Miguel. This will have to be the last one because our time is up. But if you can be brief in answering it too, please. I can't remember who wanted to ask a question anymore. Oh, so it was the same question. So with that, I think that we can close this panel. And thank you. Thank you, Etienne. Thank you, Miguel. And thank you all for having taken part in this interesting debate. May you have a nice afternoon.